Good afternoon, everyone. I'm just going to wait a little bit longer. I see some participants are still joining the Zoom invite. Okay. Well, good afternoon. My name is Sabarish Neelakanta. I'm a civil rights attorney located in West Palm Beach, Florida. I am so honored to be moderating this panel of distinguished speakers on behalf of the Florida chapter of the American Constitution Society. This panel discussion will cover significant cases, rules, and opinions issued by the Florida Supreme Court in 2022. The course will be divided into three main categories. First, we'll discuss rule changes. Second, we'll have a discussion about criminal cases that have been issued. And third, civil cases. There will also be a look into some of the larger trends that we can expect to see in the Florida Supreme Court in the years ahead. At the end, we will devote about 10 minutes or so for questions and discussion. And I encourage all participants to submit questions via the chat forum. You'll see that at the bottom. So if you just go ahead and click in there and type up your questions, or in the Q&A, I'll keep track of those and I will get those to the panelists either during the panel discussion or at the end as they come in. So without further ado, I'm excited to introduce our panelists today. First, Maegen Peak Luka. She is a partner at the law firm Newsome, Melton, where she does trial support and appellate law. She's a graduate of the University of Florida and clerk for the Honorable Emmett Cox in the 11th Circuit Court of Appeals. Maegen has been selected as a super lawyer in appellate app practice for the last 13 years, is the immediate past chair of the Florida Justice Association's Appellate Practice Section and Women's Caucus. She is also a member of the Florida Rules of Civil Procedure Committee. Welcome, Maegen. We also have Michael Ufferman. Michael is a board-certified criminal appellate lawyer and clerk for Justice Major Harding at the Florida Supreme Court for 5 years. Michael currently serves on the Florida Bar Rules of General Practice and Judicial Administration Committee and the Florida Bar Criminal Law Section Executive Council. He further served as president of the Florida Association of Criminal Defense Lawyers as president of the Florida Association of Criminal Defense Lawyers from 2015 to 2016, and is the author of the 2022 edition of the Florida Criminal Practice and Procedure Treatise. Welcome, Michael. And lastly, and certainly not least, Bryan Gowdy. Bryan Gowdy is a Florida board-certified appellate lawyer. His practice includes handling appeals, post-conviction motions, and litigation support for all matters likely to be appealed. He was a law clerk for the Honorable Maurice Hall at the U.S. District Court for the Northern District of Florida, and the Honorable Susan Black at the U.S. Court of Appeals for the 11th Circuit. Bryan has briefed and argued appeals before the U.S. Supreme Court, the U.S. Court of Appeals for the 4th, 5th, 8th, 9th, and 11th Circuits, the Supreme Court of Florida, and the Florida District Courts of Appeal. With that, and without further ado, I will turn it over to Bryan to discuss some of the statistical background and information, and then we'll move forward from there. Bryan.
Good. So good afternoon, everyone. I've put up on the screen, we're going to start with some statistics. Could you just confirm for me, Sab, is it up on the screen? Do you see it? Or is it not there?
It's there, Bryan.
Okay, great. Thanks. Well, anyway, so we're going to just start with sort of looking at what the court is doing and the numbers. And the thing I did was I went back and I looked at what the court did in 2017, and I compared it to what it's doing in 2022. So, so what you have on your screen, these are decided cases, the number of decided cases. And I have three categories: civil, criminal, and death penalty. And so what you'll see is the court is deciding far fewer cases in 2022 than it did in 2017. I think those of us who practice before the Florida Supreme Court had the sense, and that's what the numbers, bear out. You can see the court has decided 20 fewer civil cases in 2022 from 2017, about a little more than half of the criminal cases from between the 2 years. And then on the death penalty cases, it's a drastic reduction from 98 to 21. So let me go to my next slide here. Oral arguments. I think this is something else that those of us who practice have sensed that they are holding fewer oral arguments. And I went through, we counted these. We excluded when they reprimand judges. I didn't count those, but pretty much counted any type of oral argument, whether it was civil, criminal, death penalty, or rules cases, like what Megan's going to talk about in a minute. And they've had a little bit more than 50% of the oral arguments that they had in 2017. So now this is something, I think this slide, and I hope it makes sense, that should be of interest to anybody who's trying to get review in the Florida Supreme Court. What I have in the first two, the first column on the left shows the various, and I think, let me explain this. I think most people know this, but unlike the U.S. Supreme Court, the Florida Supreme Court, there's very specific bases in our state constitution on which it can accept jurisdiction of cases. It just doesn't have a freestanding writ of certiorari power like our U.S. Supreme Court. You have to fit into one of these buckets on the left-hand side. And actually, there might be a couple more buckets that aren't here because I just didn't find any cases in them. So those are the different constitutional bases. So if you go all the way to the extreme right, you'll see that these are the number of filed cases in 2022, meaning that these were cases, oops, let me go back. These were cases that were added to the court's docket in 2022. So this doesn't, the right bucket, the right column, far right column, it doesn't mean they actually decided the case. It means that there was a case filed, but it's sort of illustrative of all the different types of cases they get. And what you can see is that almost 2/3 of the filed cases seek to invoke the court's express and direct conflict jurisdiction. And, that means that there's not been a certification of a conflict. There's another category for that called certified conflict. In other words, the DCA did not certify a conflict. But the party seeking review is arguing that there's a conflict between the decision below and a decision of another DCA or the Florida Supreme Court. That's 644 of the 988 cases that were filed in the Florida Supreme Court. Now, if you go to and of course this can come up in either criminal or civil cases. So if you go to the left and you look at the two middle columns, those show you the decided cases on the merits in 2022 for civil and criminal in each category. So there were 3 express and direct conflict cases decided in 2022 and 3 criminal cases that were express and direct conflict. So like if you're arguing express and direct conflict, that's like your, what do you want to call it? Long shot, or, in football, they call it the Hail Mary pass. That's pretty much what you're doing there. There's very few of those that are going to be accepted by the court. In contrast, just above that is certified conflict. And what you'll see in the right-hand side is that last year there were 18 certified conflict cases that were filed. Again, that just means somebody filed it. So you have to keep in mind these numbers don't exactly correspond because cases may be filed in 2022 but not decided till 2024. And the cases decided in 2022 likely could have been filed in 2021 or 2020 or 2019. So this isn't a perfect analysis. But anyway, of the 18 filed certified conflict, and you'll see a total of 8 certified conflict cases decided. So the percentages seem to go way up of having your case heard by the Florida Supreme Court if you have a certified conflict. I won't go through the rest of these. The one thing you may ask is expressly declares valid state statute. You'll see only one case that was decided on that, and there were no filed cases in 2022. The reason for that, as I explained, is the case that was decided in 2022 was probably decided some earlier time. So, and let me just pause for a second on these stats. You should have on the web page that ACS put up to register, we had some materials. What I'm showing you now is not there. I've updated these since we developed those materials last week, and we will put these up sometime afterwards if anybody wants to get them. So let me quickly, because I want to turn it over to Megan, go through a couple more quick slides. So what I did is I wanted to see, like, you know, we have 7 justices, and the one thing that happened this year, of course, is that Justice Lawson left the court, I believe, like in late August, and Justice Francis succeeded him. So we've had 8 justices over the course of the 2022 year. But I kind of wanted to see, like, how are they aligning? You see this done a lot in US Supreme Court. People are always talking about, you know, the 6-3 alignment, or Chief Justice Roberts sometimes isn't there, etc. So there were 16 civil cases that were decided. And if you remember from the first slide, 16 civil cases decided in 2022. 11 of them were unanimous. In 5 of them, there was 1 dissent, and the only dissents were written by Justice Labarga. No other justice dissented in the 16 civil cases. And then you can see there were some concurring opinions. And while I didn't go back and look at 2017 on a kind of a scientific basis, I know that the old court, when we had Justice Parienta and Justice Quince and Justice Lewis, I used to see concurring opinions all the time. So far fewer of those. And here's the last thing I think I'm going to show you is the criminal cases. And there is a little bit more diversity of thought on the criminal cases. You might recall, it looks like we've got 9 cases that were unanimous, and we have 6 where there were dissents. I need to go back and, anyway, you can see the breakdown, and Justice Labarga and Justice Polston have both dissented in some of these cases. And then there's about 4 concurring opinions. So for the most part, the court is unanimous. For the most part, Justice Labarga is the one dissenting. I believe 3 of those dissents in the criminal cases were by Justice Labarga, and 3 were by Justice Polston. So that kind of gives you a sense of the court overall. And I think, the big picture, I would say, and I'm going to turn over to Megan now, is that the court seems to be deciding far fewer cases, both in the civil and criminal realm. And I think my sense is that they're doing a lot of work on the rules. So I am going to stop sharing my screen and turn it over to Megan.
Thank you, Brian. All right, I'm going to share my screen. All right, so let's talk about all of the rules that they amended in 2022. And I focused on the civil procedure stuff. They weren't afraid to touch the appellate rules too, but I'm going to fly through these to even try to cover what I can in 15 minutes. And it's in the materials, and it's so dense that you'll want to look at it to capture all the details. One of the big ones, Rule 1.442, that's the proposal for settlement rule. You can no longer have releases. You can no longer have confidentiality or any other condition, really. The only condition that you can have is that you can require a dismissal of all claims with prejudice. Outside of that, if you're requiring any other elements or your opposing party is, the proposal is not enforceable. Rule 1.530 was actually amended twice this year. Subsection A was amended to say that if you want to preserve for appeal a challenge to the sufficiency of a trial court's findings in a final judgment, that you have to raise it in a motion for rehearing. Amongst the appellate lawyers, we are pretty sure that this is going to lead to a spike in business because people are going to be concerned that they're waiving issues. I think what the court meant is that this would apply often, maybe in a summary judgment context where there are factual findings that need to be made. But be aware that it's there. And if you want to be the safe one, you probably want to file a motion for rehearing. Subsection H, basically what the court did is they deleted rule 1.535, which was the remitted additor rule, and they moved it into 1.530. So you've got 15 days to file your motion for additor or remitted. You need to give specific evidence that supports the amount that you're requesting. And you have to, the court has to state the specific criteria it relied upon, and you have to state a specific number. And failure to comply with these rules is going to mean that you're going to have a really hard time on appeal if the other side challenges what the court did. Technology amendments. Wow. So there was an entire batch of them. I believe they became effective October 1st. And Rule 1.2530, while not civil procedure, is very important. It is probably the mothership of the technology amendments. It's the one that has the most detailed requirements. In fact, my office right now, we have a Daubert hearing in February, and the doctor that I need to testify is going to be in surgery that morning. I'm going to need him to appear and testify remotely. So I need to get my motion on file, and I have to have a 10-day window for the other side to object. So you're definitely going to want to visit Rule 2.530. But the good news is that now people can testify remotely. If your expert is in Wyoming and you're in Florida, they can testify via Zoom. Technology has made giant strides. And the rule even implies that you can do it audio testimony, perhaps during a hearing. But if there is an issue of mental capacity or competency, it has to be audio video. The rule authorizes the oath to be administered remotely, and it also authorizes juror participation remotely, not only for voir dire and hardships, but also juror participation. And there's actually a specific rule of civil procedure, and we'll get there in a second. So that's 2.530, which is on the more administrative level. Now, in the actual rules of civil procedure, depositions, no longer can you or your opponent insist that it must be in person. You absolutely are authorized under the rules now to record a deposition audio visually and without leave of court or the stipulation of the parties, provided that you meet the requirements that the title of your notice of taking a deposition indicates that it will be audio visually recorded. And the notice identifies the method of recording and, if applicable, the name, address, and the name and address of the operator of the audiovisual recording equipment. There is a provision here. I break down the B4s, B5 and B7, that if you record via Zoom, you have to also record with a court reporter unless the parties stipulate. Obviously, if you record via Zoom, you don't pay anything. So the trick is to get the other side to stipulate. Whoever does record it, though, is obligated under the rules to preserve a copy. And as you would expect, if you are the one who wants to record it, you are the one who will pay for it. And B7 says that depositions can be taken via communication technology if both parties stipulate and the court orders on its own motion or through the motion of a party. So, you know, I've still seen cases where somebody represents elderly clients and their elderly clients are in fragile health and they do not want to do an in-person. And so there is a fight over it. And the court is obviously authorized to make a call in that specific situation. I did note I wasn't involved in the committee that was drafting the rule amendments, but there's some inconsistency in their language. I think method of recording and the specific form of communication technology used are supposed to be the same thing. I can't imagine how they would be different, but be aware that 1.310C2 is new, and it says that if you want to use audio or audio-visual recording at a hearing or trial, that you must have a copy of the transcript filed with the court. So if you want to play a deposition, for example, you have to file a copy of the transcript. And actually coming soon to a theater near you is an amendment to the rules that is going to require that that transcript can only be in full-sized format. It can't be a mini, which I encourage you to do anyways for the sake of your appellate lawyers, because we're not supposed to be able to use minis if we have to do an appendix, and the appellate courts hate them in a record. So that's some inside baseball. Only file the full size. Subpoenas, you are now required to include the details from 1.310B4 in the subpoena, which is the method of recording, who is going to record it, and instructions for accessing it. Rule 1.430, in my personal opinion, is a big change. It's all new, and it allows jurors to participate through audio-video communication technology. So you can do voir dire this way. It allows you, the rule creates the flexibility that you could agree to do voir dire remotely and then call the jurors in person, but it also allows in-panel jurors to participate through audio-video communication if the parties have stipulated in writing and the court has authorized it. If you want to have jurors participate this way, you have to serve a written motion requesting it along with the stipulation, because remember, you can't do it unless the parties stipulate and the court authorizes it, both. And if you want to do it, it can't be a last minute decision, because you have to do it within 60 days after service of a demand for jury trial or within other such period as may be directed by the court. 1.440, setting the action for trial, says your notice for trial must indicate in jury trial cases that the court has authorized the petition of prospective jurors and panel jurors through audiovisual communication. The 1.451, which was about taking testimony, has been deleted. The reason why is because it required a witness testifying at trial to be physically present, and that's no longer necessary. And it also required administering oaths in person. 1.700 is interesting to me. So all of these technology amendments, and then 1.700 says that absent a court order stating to the contrary, mediation must be conducted in person unless the parties stipulate or the court on its own motion or motion by a party says that it can be remote. I know during COVID, there were a lot of remote mediations. It's curious to me why they would start from the premise that it has to be conducted in person unless you stipulate otherwise, but I didn't write it. That's just the way it is. Be aware. A2 says that if you're going to use communication technology, you have to notify the parties within 15 days of selection of the mediator and give the instructions for accessing the mediation remotely. Of course, if you're picking your mediator at the last second, right up on a deadline, you can't comply with that. So I don't know how rigidly that rule is going to be enforced. 1.730 says that signatures to an agreement may be original, electronic, or facsimile, and maybe in counterparts. And C says, this is a new one, that parties cannot object to the enforceability of an agreement on the ground that communication technology was used, so long as it was authorized under 1.700A. So make sure when you're going to mediation that if you're going to do it via Zoom, that you have followed the rules of 1.700A, because if you don't, then this new provision C is the opportunity for the other side to wiggle their way out of your agreement. County court, this one was curious to me because it mirrors the mediation and circuit court in the sense that you can appear by communication technology and agreements can be signed electronically and in counterparts, but there is no provision that says a party cannot object if communication technology was used. So that's only at the circuit court level, which is interesting. I'm not sure if anybody noted the admission to the committee, but nerds like me do that. So let's see. Voluntary binding arbitration says that that can also be done via communication technology, which is nice because that helps bring down the cost. And the last one that I will cover on this page is Appendix 2, which is the statewide uniform guidelines for taxation of costs, has caught up to the communication technology, I suppose. They said that they now specifically delineate that the things that should be taxed. Remember, there's 3 categories: should, may, and should not. The should includes filing fees and service of process. That I think judges have typically always taxed those, but now they've been made explicit. And things that may be taxed: the cost of court-ordered non-binding arbitration, including arbitrator fees. And for testifying experts, a reasonable fee for conducting examinations, investigations, tests, research, and preparing reports, a reasonable fee for testimony at court-ordered non-binding arbitration, and a reasonable fee for preparing for deposition, court-ordered non-binding arbitration, and/or court testimony. So that should be helpful for trial judges when they're trying to evaluate prevailing party motions or PFS motions, or even statutory cost shifting provisions. And as for the appellate rules, I will just make one note. Bryan and I participated in this one, trying to convince the Supreme Court that it was a really bad idea to make orders either granting or denying a motion for leave to amend to add a punitive damages claim immediately appealable as a non-final order. Our pleas fell on deaf ears, and that is now a part of 9.130. So if a party moves for punitive damages, and like I said, whether it's granted or denied, it's immediately appealable. And that was one that was quite remarkable to me, so throwing it in at the end. And I think I am right at my 15-minute mark.
Okay, I think I'm next up. Good afternoon, everyone. I am going to discuss criminal cases and a particular trend in criminal cases from the Florida Supreme Court. I provided materials that outline some of the key cases that were decided in 2022. I also put in there some cases that are pending in front of the court right now. But for the trend that I want to focus on, it's not necessarily encompassed by the cases from 2022, but you have to go back to the 2 previous years. And the trend is this: the Florida Supreme Court, in a series of cases, has receded from some long-standing principles that have applied to criminal cases in a couple instances for decades, and in another instance, something that was just decided by the court prior to Justices Pariente, Quentin Lewis retiring. And I think a lot of it is summed up by Justice LaBarga's dissent in the Lawrence case. And as Bryan mentioned earlier with the statistics, Justice LaBarga is, when there is a dissent in these criminal cases, it's mainly Justice LaBarga. Justice Polston has joined him in a couple of those cases. But the Lawrence case dealt with the Florida Supreme Court's review in death penalty cases. And when someone's given the death penalty in the state of Florida, there's an automatic appeal directly to the Florida Supreme Court. The DCAs don't get involved in death penalty cases. Death penalty cases have generally taken up most of the Supreme Court's docket. And part of the death penalty review would involve, as with any other appeal, issues that errors that may have occurred during the trial, errors that may have occurred during the sentencing process. But the key part that was at issue in Lawrence is, for the last 50 years, the Florida Supreme Court has had, as part of its review, a proportionality analysis. If they conclude that there were no errors in the trial, no errors during the penalty phase, and they're getting ready to affirm both the conviction and the sentence of death, there was a requirement that existed for many, many decades that the Florida Supreme Court would also compare the facts of that particular case to other cases and make sure that it was proportionate to give the death penalty in that particular case. If there were other similar cases where the death penalty had been reversed for whatever reason, or the death penalty was not imposed, and the facts of this case were not more egregious than those other cases where there had been no death penalty, then the Florida Supreme Court would conduct the proportionality analysis and potentially conclude that it would be disproportionate under the 8th Amendment to keep the death sentence in place. In the Lawrence case, the majority overturned that precedent and said that's not required under the Florida Constitution. They questioned why that proportionality analysis even had been occurring over the last many decades. And they said from that point forward, they would no longer conduct any proportionality analysis. Justice Labarga dissented, explained that this is part of the court's jurisprudence for the last 50 years. And most importantly, he said this is very important for the Florida Supreme Court to ensure that a particular death sentence does not violate the Eighth Amendment. In his dissenting opinion, Justice Labarga went on to say that it's not only this case, but there's some other cases that have greatly changed how the Florida Supreme Court considers death penalty cases. One of the cases that he cited to was a case called Poole. Poole concerns whether or not a jury's recommendation for death must be unanimous. In a case called Hurst, that was issued in 2016, just before Justices Perriente, Quince, and Lewis retired, the Florida Supreme Court held that in order for the death penalty to be imposed, the jury must recommend unanimously that the death penalty be given in that particular case. At the time, Florida was an outlier. I think Florida and Alabama were two of the only states in the country that didn't require unanimous recommendation for death. In Hurst, the Florida Supreme Court made it so we were no longer an outlier and required that there be unanimous jury recommendations of death. Interestingly, right after that, the Florida legislature, obviously in compliance with Hurst, changed the statutes in Florida and said, yes, in order for the death penalty to be imposed, there must be unanimous recommendation for death. However, in the Poole case decided in 2020, just 4 years after Hurst, the Florida Supreme Court receded from what they had just said in Hurst and said, nope, the Hurst majority got it wrong. There's nothing under the Sixth Amendment that requires a jury to unanimously recommend a sentence of death. So even though the court in Poole receded from Hurst and said you no longer need unanimous jury recommendation for death, the legislature has not changed that statute yet. And that became an issue earlier last summer, actually last fall, during the Cruz case, the Parkland shooting case, because in that case, the jury did not recommend unanimously for the death penalty be imposed in that case. And many people on the side of the state have come out and pointed to the fact that in Poole, the Florida Supreme Court receded from Hurst, and maybe the legislature needs to change that statute. I tend to believe that Florida should remain consistent with the other states that do have the death penalty that require a unanimous jury recommendation. I don't know what the legislature is going to do this upcoming session, but I'm sure that's one of its considerations. But that's one example that in the Lawrence case, Justice Labarga pointed to. The other example that he pointed to was the circumstantial evidence rule. And in Florida, for the last 100 years, we have had two different standards for a court to consider what's called a motion for judgment of acquittal, whether or not the evidence is sufficient to allow the case to go to a jury, or whether or not the judge should step in and say, I think the evidence is insufficient in this case. And if the evidence is direct, if there's an eyewitness, if a defendant allegedly makes a confession, then the standard is pretty straightforward. A trial judge must deny the motion for judgment of acquittal if there's any evidence in the light most favorable to the state that would support the elements of the crime. But under the circumstantial evidence rule, if the evidence in a case is wholly circumstantial, no direct evidence, it's only based on circumstantial evidence, stacking of inferences, then there was a special standard of review that applied. And I'll quote from it, where the only proof of guilt is circumstantial, no matter how strongly the evidence might suggest guilt, a conviction cannot be sustained unless the evidence is inconsistent with any reasonable hypothesis of innocence. So that had been the circumstantial evidence standard for over 100 years. If the case was only based on circumstantial evidence, if there was a reasonable hypothesis of innocence that the state could not refute, then a court, whether the trial court or on appeal, the appellate court, would be required to overturn that conviction. Obviously, that applies in all criminal cases, not just death penalty cases. But in the case called Bush, also decided in 2020, the Florida Supreme Court receded from the circumstantial evidence standard and said, from this point forward, regardless of what the type of evidence is, whether it's circumstantial or direct, it's the same standard of review that applies. You look at the evidence and the light most favorable to the state. And if there's any evidence that would support the elements of the crime, then the judge is required to deny a motion for judgment of acquittal. Justice Labarga in his Lawrence case also cited to Bush and said, in light of this case where we're no longer conducting proportionality review, in light of Poole, where we're no longer going to require unanimous recommendations for death, and in light of Bush, where we're getting rid of the circumstantial evidence special standard of review, it's going to make it potentially a possibility that someone has been convicted of first-degree murder based on circumstantial evidence alone, someone has been given the death penalty on something less than a recommendation, a unanimous recommendation of death, and someone could still go and be executed in the state of Florida, even if that sentence would not be proportionate to other sentences, because the Florida Supreme Court has receded from those precedents over just the last couple of years. Another case where the Florida Supreme Court receded from precedent is the case of Davis from 2021. And this is a case where Justice Polston wrote the dissenting opinion and Justice Labarga agreed with him. And the issue in Davis was if a defendant invokes his or her right to remain silent during the trial or maintains during the trial that he or she is innocent, can a judge use that against the defendant during the sentencing hearing? And in Davis, the majority receded from cases both from the Florida Supreme Court and from every district court of appeal and held that nothing prohibits a judge from using a defendant's silence or the refusal to admit guilt against that defendant during the sentencing hearing. Justice Polston dissented. He said that you have a Fifth Amendment right under our Constitution to remain silent. And he says, accordingly, I would hold that a trial court violates a defendant's constitutional right to due process and the right against self-incrimination, where it penalizes a defendant for failing to admit guilt during a sentencing hearing. So again, prior to Davis, for many decades in Florida, if a judge makes a comment such as, I'm going to give you the maximum sentence because you refused to accept responsibility, that would be something that the Florida courts would overturn and say that's a violation of the defendant's Fifth Amendment rights. But after Davis, if a defendant does not expressly show remorse or accept responsibility or admit guilt, that's a factor that a judge can actually use to further penalize the defendant at a sentencing hearing in Florida. So those are just a couple of the trends or a couple of the cases that support the trend that the Florida Supreme Court is receding from a lot of these long-standing principles that apply in criminal law. Some of the safeguards that make it so an innocent defendant would not be convicted or an innocent defendant would not be potentially executed. Another one that happened recently is we used to have the ability as appellate lawyers to raise ineffective assistance of counsel claims on direct appeal if the claim was apparent from the face of the record. But in a case called Steger from 2021, the Florida Supreme Court receded from that as well and said no longer can a defendant raise an ineffective assistance of counsel claim on direct appeal unless the claim would amount to fundamental error or unless this claim was somehow preserved. It's hard to fathom how an ineffectiveness claim could be preserved by the trial attorney himself or herself during the trial. Some courts have still continued to apply the fundamental error standard, but again, it's making it less likely that you can raise that claim on direct appeal. The Florida Supreme Court said you'd have to raise that claim only in a post-conviction motion pursuant to Florida Rule of Criminal Procedure 3.850, but you would not be able to raise that type of claim on direct appeal. I think that's it. I think that's the big trend as far as criminal cases in Florida. You can see from the packet that I provided that there were some situations where the Florida Supreme Court has reversed criminal convictions. Just last year, the Florida Supreme Court reversed the Simpson case, the conviction of the Simpson case, because there was a Brady violation. The state had failed to disclose that the victim's son was acting as a confidential informant in the investigation of a key witness. In the Absnu case, the Florida Supreme Court also reversed a conviction because the state perpetuated a witness's testimony to be presented at trial, but the equipment, the audiovisual equipment that was used in that case didn't allow the defendant, when that witness's testimony was being perpetuated, to have contact or visual contact with the witness. And the Florida Supreme Court held that therefore violated the Sixth Amendment right to confront the witnesses against you. And then there's also some other cases where the Florida Supreme Court has reversed some other trends, some other precedent that they've had. We used to have a per se reversal requirement if there was a judge who should have been disqualified but remained on the case. If you could establish that on appeal, it had been held that would be per se reversible and would afford you a new trial. In the Davis case from last year, the Florida Supreme Court receded from that as well and said, no, this is no longer subject to a per se reversible error rule. It's now going to be subject to harmless error, and you'd have to consider each case on a case-by-case basis to determine whether or not the defendant was prejudiced by the judge's erroneous decision to not disqualify himself or herself. Okay, I think that's almost the end of my time. Let me turn it over to Bryan, and then of course we'll answer any questions that you have at the conclusion of the presentation.
Hey, Sab, it's all right. I was going to try to answer a couple questions. Let me share screen again because I realized someone asked me a question that made me realize I don't know how to read my own slide. Someone asked me about the total about this slide, and I misread it. The number at the very bottom and the right says 998. Those are original proceedings. Those are petitions for writs. I haven't broken down that number, but I think it's probably safe to say that a large number of those are petitions for writs of habeas corpus by prisoners. And if you look over to the middle two columns, very, 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 very few of those are granted, one and five. I had said that express and direct conflict was roughly 2/3 of the filed cases. That, and somebody asked me what were the other 250. They're actually more like 94% of the filed cases. I was looking at that 998 as a total. That's not a total. And I say 98%. Let me clarify that even further. It's like 94% of the filed cases, excluding the original proceedings. I think, like, to do a good analysis, you should throw those out because most of them are, not probably well taken petitions, pro se petitions. So, so express and direct conflict is about 94% of all other filed cases, and only 6 of those were granted. So it's a pretty low percentage. And I see some questions about why do you think the number of cases dropped? And also, if the court was really trying to transform the legal landscape, do you think they would accept more? So I think the reason that the number of cases have dropped, and Maegen and Michael can chime in on this if they want, is that the court takes a rather dim view of express and direct conflict, which we just discussed. You saw the numbers I just went over, 3 and 3 out of 644. I think the prior court had a far more expansive reading of express and direct conflict. And so I think that's why, that's part of the reason you're seeing the numbers reduce. Maegen and Michael, would you like to answer that question?
I think that's right. I think that there's actually a case called Cartsonis. It was my case where when I worked at the Florida Supreme Court many years ago, there was a guide that the law clerks used amongst themselves. It was written by Craig Waters, who recently retired, and it was in the Nova Law Review, and it's a wonderful treatise on the practice in front of the Florida Supreme Court, and he has a section in there about the court accepting jurisdiction. It was recently updated and added to the authors, Tom Hall, Justice Kogan, and Justice Anstead. So anyone that has a case in front of the Florida Supreme Court, I highly recommend that you get a copy of Craig's treatise. In there, Craig mentioned that the court would have the ability to not only accept express and direct conflict, but also an apparent conflict. If by reading the two opinions, you would come away from the opinions that there's at the very least an apparent conflict between these two, that would be okay for the court to accept that type of conflict. In the Cartsonis case, the Florida Supreme Court seemingly receded from that and said, we don't have apparent conflict jurisdiction, and our express and direct conflict jurisdiction is very narrow, and you must find that express and direct conflict within the 4 corners of the opinions at issue. So I agree. I think they are narrowing their interpretation of the ways for which they can accept a case.
So, hey, Sab, we have 15 minutes and I see lots of questions in the chat. Why don't, if it's okay with you, I'll just hit these 3 things I was going to say very, very quickly, and then turn it over to you, and you can throw the questions at whoever you want. Throw them to Maegen. But anyway, my 3 quick points on the civil cases. as far as larger trends are, we continue to see that on the interpretation of texts or instruments of any sort, contracts, statutes, constitutional provision, the court is tightly wedded to Justice Scalia and Bryan Gardner's book and their theories of textualism. You see that book cited all the time. I related to that, I would say that this court seems far more comfortable citing treatises and law review articles than the prior court. And I had some other points that are in, there are materials, and the materials that we've been going over will be posted on the website. So you can see some of these, but the big one I wanted to point out, it's actually in a criminal case, but it applies across the board to anything you're doing, is the Connage v. United States case. And there the court receded in part from a 1984 case called Holly v. Auld. And this, I can just tell you, comes straight out of Justice Scalia and Bryan Gardner's book, in that they reject the principle that a court has to first determine whether the text is clear and unambiguous before resorting to rules of construction. And that what they kind of announce in Connage is that we're going to do this whole text analysis, and we will apply the rules of construction from the get-go. So that's a very significant change in statutory interpretation. Though I think you could find cases beforehand doing that as a practical matter, but now they've come out and expressly said so. My second big point is the court's narrowing the use of extraordinary writs. I have some examples in the materials, but I think, you know, if you're looking to stay out of the Florida Supreme Court and it's a review of an extraordinary writ, you need to look at those cases. The court, just like with express and direct conflict, I think the court's taking a dim view, not just of its own extraordinary writ power, but the extraordinary writ power of the DCAs. I think they're tightening that. And then the third trend is this is a pro-arbitration court. There's two decisions, Hayslip and then Airbnb, where, you know, the court enforced arbitration. And I think that's a trend will continue. So then I'll let Saab try to throw these questions where he thinks they should go.
Thank you. Thank you, everyone. That absolutely wonderful presentations from all of you. A few questions here. I just want to let everyone know the presentations, the slides will be made available after the CLE. There is a link to the right there on the webinar chat that you can click on, and everything will be posted there. So you'll be able to get a copy of some of the topics and slides that are being discussed here today. So let's start with David Karp's question here. And Bryan, maybe this is a question for you. Why do you think the number of cases the Supreme Court has decided has dropped so much? Surely it can't be that the population has shrunk and we have fewer legal issues to decide. I know, there was a discussion that, previously there was a tremendous number of cases that were being argued, and now that the number has shrunk quite considerably. What do you think is the reason for that, Bryan? Do you have any thoughts on that?
Well, I think I answered that, Saab, in that I think they take a dim view of express and direct conflict, and that's the most of the cases there. So, and they also, as I've mentioned, they also take a dim view of, I think the extraordinary writ power. I think we're going to see more restrictions on their extraordinary writ power. One example of that is just before the holiday, the Bone v. Florida 5th District Court of Appeal Judicial Nominating Commission that dealt with the issue of whether there were people that had been, there were applicants who were nominated to the governor for appointment to the 5th and 6th District Courts of Appeal who did not live in the 5th or 6th districts at the time of the nomination. And the court ruled that was fine. as long as they lived in the district at the time the governor appointed them. But if on this question, there was a hint in that opinion about whether the court should continue to allow citizen and taxpayer standing that allowed this type of challenge to go forward. For those of you familiar with this, a petition for writ of quo warranto, anybody can file in Florida. You really don't have to show individual injury. And there's a line in there that I would say is a hint that they may revisit that. So anyway, I think they're about restricting judicial power, and that's the answer to David's question.
Thank you. And Maegen, there was an interesting question here that was put out to you regarding the sort of the interplay between the Sunshine Law and these rules that are being sort of taken, these amendments that are being made in the Supreme Court level. I was hoping you could talk a little bit about that. I think that's an interesting thought, because we do see a situation here where there doesn't seem to be much public opinion or thought or expression or criticism into what these rule changes could do. I thought you could discuss that. I know you also answered it on the chat, and I wanted you to finish the thought at the end. You stated that in any way,
yeah, I ran out of space. Yeah. It cut me off. So Article 3, Section 2A says the Supreme Court shall adopt rules for the practice and procedure in all courts, including the time for seeking appellate review, the administrative supervision of all courts, the transfer of the court having jurisdiction. The Supreme Court shall adopt rules to allow the court and district courts to submit questions, blah, blah, blah. So basically, the Supreme Court is given the authority to adopt rules by the Florida Constitution, but doesn't say how they have to do it. And for decades, they have done it with a committee system. And it appears, because I serve on the Civil Procedure Rules Committee, it appears that they are increasingly frustrated with the amount of time that it takes. And on December 8th, so everyone's probably familiar with the fact that the Florida Supreme Court, they've assembled many work groups. The work group on the proposed amendments to the Florida Rules of Civil Procedure is one of many. But that is the work group that has proposed a massive overhaul to the Florida Rules of Civil Procedure. And the court held oral argument on all of those proposals on December 8th. And it went for 4 hours. I was pleasantly surprised at how receptive the court appeared to be to hearing the comments. I think it was really good for the court to see that, there was a work group of 12, and to their great credit, they had to have busted their butts to get the amount of work done that they did. But the work group had direct access to the justices for input from them. And the work group had resources, paid resources, people to do research for them, to look at rules in other states, people to type up the rules for them. There was a lot of, the work group members were volunteering a ton of their time, do not get me wrong, but they also had administrative assistance. And because of that, they were able to get a large amount of work done in a short amount of time. And it was something that was covered with the Supreme Court, because the chair of the Civil Rules Committee spoke, I spoke, and then I don't know how many of you know Paul Regensdorf. He's semi-retired and very unafraid to speak his mind. And he also addressed the court, saying that the work group system, while nice in theory, creates enormous risk of unintended consequences. Basically, the court has a theory about what works. And then, for example, I think the summary judgment rule that went into effect last year is probably not a good example. That had been on multiple justices' agendas, I think, for a very long time. And the timing presented itself, and they've made the change. The apex doctrine, that was actually my case at the Florida Supreme Court. And again, I think that was a moment of opportunity that they seized upon those are examples of them changing the rules without any work group or any input. Just, this is the way it's going to be. Justice Muniz did that in opinion with sovereign immunity. It used to be that you could only immediately appeal a sovereign immunity case if the court found as a matter of law that sovereign immunity didn't apply. If the court found that it was a question of fact, then it wasn't immediately appealable. And in an opinion, Muniz said that that would be changing. And we, in this oral argument, urged the court that when you do it that way, you take the benefit of the committee away, because the committee has plaintiffs' lawyers and defense lawyers, it has trial lawyers, it has appellate lawyers, it has probate and real estate and all facets of the practice of law who are able to provide input. And when you, yes, it takes longer when you do it that way, but you get a more balanced rule. I think that the court, someone else asked, why do you think they're going to these work group processes? I genuinely get the impression it's because they feel like the committee system takes too much time. And I don't think that they're wrong in feeling that way. Sometimes a rule can sit in committee for a year because internally the committee is meeting multiple times. If there's lots of arguments, everybody gets an opportunity to speak. We'll go through multiple drafts, and doing anything by committee takes a while. So we urged, and Muniz seemed kind of receptive to it. All right, if you're concerned about time, then send it to the rules committee and tell them that they have 6 months. Give them a guideline of what's acceptable to you, and then they can operate within that parameter to get it done. But please stop doing this yourself, because when you do it yourself, for example, the PFS rule, that's a situation where, as it was originally drafted, the people who write rules and the appellate lawyers who then go argue about them could see all the problems with it that the court itself can't see. So that was a diatribe about, I don't know that we have a basis to argue that anything done in the rules should be in the sunshine. I think my read of the Constitution is that the court is given the authority to do it however it wants to do it. It's typically done it with the committee system. It's unhappy with the committee system so that it's experimenting with something different. The committees are trying their best to say, please give it back to us. And the Supreme Court is experimenting with the work group system because, like I said, they have multiple out there. But I do want to say that I don't think they're all bad. For example, it came up during oral argument that there is a committee whose report is due to the Supreme Court in February. And that one is looking at issues like the unavailability of hearing time and how can we create rules to address that so that litigants aren't struggling to get hearing time. And that's just one of many issues that committee is addressing. But like I said, they're given resources and access and opportunities that the committees aren't. So it's not all bad. It definitely has weaknesses. And that's all the information I have.
Oh, very interesting. I mean, the issue of the technology mediations in county court and how that does not apply on the circuit court level and the county court level. I mean, that's something that I'm assuming was addressed or was not addressed by during the work group process, or what happened there?
I wasn't part of that one, so I don't know.
Okay.
But I mean, when it goes to, I can tell you that in my participation in committee, when we look at them, there's always, I would imagine we've all experienced it. You can write a draft and you can think it looks good, and you can come back and touch it 2 weeks later and you can see how that sentence is just so unclear and it needs to be rewritten, where it looked great 2 weeks ago. And it's part of the process why it takes so long. But yes, for that particular one, and like I said, there are other inconsistencies that I could see that, when you're hustling to get it to print, you lose the opportunity to make those polishes. And I genuinely don't think, like with the work group, their rules, I submitted a comment about the rules. I think it was 110 pages long, pointing out all of the inconsistencies. And when I saw the work group members at the oral argument, they were appreciative. They didn't take it personally. They said, honestly, we didn't see those and we don't want to make those mistakes. It's not that we were intending to do that. We're just human beings. So I have a feeling that's just what happened. Nobody caught the inconsistency.
Got it. Thank you, Maegen. I think we're kind of close to time, but I do want to see if we can get one more question in, and maybe Michael, if you could answer this. How does the court explain its reasoning for receding from precedent other than the change in justices? Was Davis regarding sentencing considerations not based on longstanding U.S. Supreme Court precedent. I mean, is this simply just the constitution of justices here, or how are they explaining this sort of change in decision making?
I'll be quick. In regards to the Davis question, I think Justice Polston addresses that in his dissent. There is a case from the U.S. Supreme Court called Grayson that the majority relied upon, where the defendant gave false testimony in the mind of the judge, and the judge relied upon that. And Justice Polston said it's one thing for a defendant to give false testimony during a trial and have that be utilized against him. That happens all the time in the federal system with obstruction enhancements. But what Justice Polston's concern was a defendant who didn't testify, maintains innocence, and that's nevertheless going to be used against him. And he said, therefore, he distinguished that U.S. Supreme Court case. The bigger question: how do judges get around stare decisis principles? I think that there's arguments on either side. The Dobbs case from the U.S. Supreme Court last year is a great example of that. I can remember when I clerked for Justice Harding, he wrote a dissenting opinion that said, I can't agree to recede from whatever the precedent was in question, because the only thing that I think that has changed between today and 3 years ago before I was on the court is the membership of the court, and that's not a valid basis to recede from precedent. So you have that argument on one side, but then you have the argument such as in Dobbs, where the U.S. Supreme Court said, wait, we have an obligation to correct an error if the error has been wrong from its inception. That's what they said in Dobbs. I think that's what the Florida Supreme Court majority is saying in a lot of these opinions when they're receding, is that, look, in the case where in Hearst, where you said you need unanimous jury recommendations of death, that was wrong when it was decided, and we're now correcting that error in the law. Stare decisis doesn't prevent us from doing so. So there's arguments on either side, and whoever controls the majority is the one that gets to carry the day.
And Saab, can I jump in real quick?
Absolutely.
I know we're over time. Yeah, I mean, this court has adopted Justice Thomas's view of stare decisis. They've said that in a few opinions. So, and that view essentially is that, they look at almost every question anew, and if they consider the prior decision to be erroneous, then there's almost like a presumption they should recede from it, unless you can come forward with why there should be reliance interests. And I don't think, I think it's a little, well, at this U.S. Supreme Court, it's always hard. I probably stepping off a ledge here, but I don't think there's 5 votes there yet for Justice Thomas's view on stare decisis, but there's a majority at our court that has that view, I would say. So anyway, I'll leave it at that. There's lots of good questions in the chat, but I think I know we want to keep on time here.
Right. Well, I think, I think people are jumping off as well. So I wanted to thank the panelists here for their time. Thank you very much for your informative presentations. All the participants, thank you for joining us today. Have a wonderful day, wonderful weekend. Happy New Year. Take care.